Okay, chapter 12, landlords and tenants. In this chapter, we're going to be explaining the characteristics of leasehold estates. See, when it comes to purchasing real estate, we had a bunch of different chapters for types of estates and land and types of ownership and contracts and real estate contracts and et cetera, et cetera, et cetera. Pertaining to leases, all this stuff is going to be bundled into one chapter now. We're going to explain to the leasehold estates, the four types of leasehold estates. We're going to describe provisions in leases, including various forms of eviction. We're going to learn what eviction is. We're going to learn about the Truth in Renting Act and the Americans with Disabilities Act, even though we learned about some of that stuff in the anti-discriminatory chapter 4. Um, we're going to discuss differences between various types of leases, and then we're going to identify what the primary functions of a property manager are. So, what is a lease? Well, a lease is an intangible or incorporeal asset that is considered personal property. The owner, who is the lessor, intentionally transfers most of their rights, like the right of possession of their premises, to the tenant, who is the lessee, for a limited period of time as defined in the lease. Remember, they also pass along all those rights that they get in the bundle of rights to keep others out of their property, etc. They just don't pass on the right to sell it. So the lease also sets forth the length of the contract, the amount to be paid for the right to use the property, and defines the rights and obligations of the parties. Demise, every lease has a demising clause in it. What is that? Well, demise is a transfer of property by lease. It says that the landlord is to let the premises and the tenant is to take possession of it. So every lease has a demising clause describing what the landlord is exactly renting and that the tenant is taking possession. So because of that, a lease is both a contract and a conveyance. Okay. So that you try and take a picture of the screen. If you are, you just turn it sideways. I don't know if you are or if you aren't. If you're doing something else, I don't know. Okay, well, there she goes. All right, so yeah, if you turn your camera to the side, it may give it a different view and may be able to get a better picture without the wavy lines, unless you're just video chatting with somebody. I don't know. All right, let's see. Elise, let's do the highlights now. These are the things that were on the previous slide, as well as things that were in the previous chapter that are going to be on a coming slide, like New Jersey Statute of Frauds says that all leases, if they're more than 3 years, they're required to be in writing, but anything less than 3 years is not required to. I mean, it's smarter to get it in writing, but you're not required to have a lease in writing unless a real estate agent's involved if it's less than 3 years. If it's 2 or more years, you can record that long-term lease. Okay, everybody good?
Got it.
All right, so once again, this is not a new slide right here. You've seen this before. Sales contracts for real estate have to always be in writing, but leases, they only need to be in writing if a real estate agent's involved or if they're 3 or more years. And if they're 2 or more years, they can be recorded in the public record. Estate and land describes the amount and kind of interest that one has in real property. And there are two categories of estates: freehold, that's the ownership category, and there's three types of freehold estates. And then we have the leasehold estates, which there are four types of leasehold estates. Dare I bring up and ask you guys what are the three types of freehold estates? The categories of
Estate
ownership.
for years, periodic
period, time
You know,
period.
not the leasehold estates, the three types of freehold, the ones that describe ownership.
Simple fee, fee
Oh, yeah.
determinable, and life estate.
I'm sorry, I didn't catch the first one.
Fee simple.
Yep. So fee also goes by fee simple, or fee simple absolute. You got fee determinable, which also goes as a conditional fee or defeasible fee estate. That is ownership forever based on a restriction. And then the last one was a life estate, right? What do you call a life estate that's not based on your life, but someone else's? See if you remember that little Latin term. Per optra vi. A life estate per optra vi, for the life of another. Okay, and then we have a leasehold estate. There's four types of leasehold estates, and that's what we're going to focus on in this chapter. They're less than freehold. You're not free to hold it forever or a lifetime. So leaseholds are not ownership, so therefore it's personal property. So an owner intentionally transfers some of their rights and interest in the real estate they own to a tenant for a limited period of time as defined in a lease. So a lease is considered to be personal property that is an intangible or incorporeal asset. So there are four types of leasehold estates, and just to run them down really quick and get through some of this other terminology before we go into each one in detail. We have an estate for years. These are the four types of leasehold estates: an estate for years, periodic estate, estate or tenancy at will, and an estate or tenancy at sufferance. Now, rent is due at specific intervals per the lease. Now, a little unknown factoid here. If you don't specifically state in the lease when the rent is due, according to New Jersey law, it's due in the arrears. That means at the end of the term for which the lease is for. So most people know that, yeah, you got to pay the rent on the first of the month, right? Well, that's because the landlord writes it in the lease. But if they did not write in the lease when the rent is due, according to New Jersey law, it's due in the arrears at the end of the month, the opposite of in advance. And anyone who terminates a lease early is in breach of contract. A holdover tenant is someone who has held over the occupancy of the premises they did not vacate after their lease term had expired. The landlord could either accept the holdover tenant and any future payments from them, or they could evict them for not signing a new lease. So what is a holdover tenant? It's just somebody who did not leave after their lease expired. Is that negative? Not necessarily. If they're paying the rent and the landlord's okay with it, then it's fine. Now, eviction is the legal process of removing a tenant through the court system. A landlord cannot lock out a tenant or turn off their services or physically remove them. The tenant has rights. Even if they're not paying rent, they have rights. Okay? Eviction is the process of revoking those rights that were granted to them in the lease. You know, we learned that you can't take away someone's rights once they have them, right? But if they were given rights that were conditional and for a limited period of time as defined in the lease, and as long as you did not violate the terms of the lease, if they're now violating the terms of the lease, now you could evict them. But eviction is the legal process of removing a tenant and revoking those rights through the court system. We can't take them away, but the court can. So eviction is that process of revoking the rights because the tenant violated the terms they agreed to in the lease, which granted those rights, or the lease expired that granted them those rights to be there. And they didn't sign a new one. So now you got to go. So let's write 4 leasehold estates. And there's estate for years, periodic estate, tenancy at will, tenancy at sufferance. And then just beneath that, there are, let's look over what the distinguishing characteristics of the different leasehold estates are. So we're going to write a few words behind after these things, like distinguishing characteristics, right, of a leasehold estate. Where it says for a definite period of time, estate for years is for a definite period of time. That's its distinguishing characteristics. It's for a fixed term with an end date in it. To be more exact, what a definite period of time means. It means that it's for a fixed term with an end date. You know when it begins, you know when it ends. When it ends, unless you sign a new lease, you got to go. And a periodic estate, also known as an estate from period to period, this type of lease, its distinguishing characteristic is that it automatically renews. It does have a date in it, but that date's not an expiration date. It is a renewal date. So right there that it has a renewal date in it. An estate at will, it's for an indefinite period of time, an undefined period of time. I want you to associate the word indefinite with the estate at will. And then an estate at sufferance is one without the landlord's consent. I'll get into more of the details of what these are. We're just looking at the distinguishing characteristics of these leasehold estates. Let me know when you got that stuff written down.
So there's no difference ever in definition between when they call these things estate or tenancy.
Yeah,
Like I'll see
estate.
estate at will and tenancy at will.
It's the
It's all
same
the
thing.
same.
Yeah, it's the same thing. Same thing.
We're good.
All right. Got it. So here, I write down what those four distinguishing characteristics are on my own slide here. Estate for years is a lease for a definite period of time for a fixed term, has an end date in it. You know when it ends. If you did not renew the lease, you got to be out by the time the lease ends. Periodic estates, period to period. This is a type of leasehold estate that automatically renews for the same amount of time the original lease was written for. It has a date in it, but it's a renewal date. And that renewal date's important because if you do not wish to renew the lease, you need to give notice to the landlord that you're not going to renew it, that you're going to quit. They call it a notice to quit. Because if you don't, well, then it automatically renews for the same amount of time that the original lease was written for. If it's a year lease, it renews for a year. If it's for 6 months, it renews for 6 months. If it was 2 years, it renews for 2 years, and so on. If it's a month, then it renews for another month, right?
That's like the subscriptions to like Netflix and all these things that if you don't tell them, they just automatically
Yep.
keep going.
Yep, it'll automatically renew. Correct. So an estate or tenancy at will is a lease for an indefinite period of time, an undefined period of time. An estate or tenancy at sufferance is one that's created without the landlord's consent. We'll get into the details of what that is in the next slides that are coming up as we dive deeper. Let's start off with the estate for years and do the highlights here. I got the screenshot for the highlights and I'll give the explanation. Don't let the term estate for years fool you. It doesn't need to be for a period of years or more. An estate for years, its defining characteristic is that it's for a fixed term with an end date. It could be for 1 month, it could be for a week, it could be for 3 months, it could be a year, it could be 2 years. The distinguishing characteristic is you know when it begins, you know when it ends. Has an end date in it. So it's for a specific period of time. No notice to quit is required to terminate this at the end of the term because it has an end date. So you know when that expiration date comes about, if you didn't sign a new lease, you got to go. So the landlord doesn't need to give any further notice that you need to vacate at the end of the lease term. You know when you need to vacate, when it expires. Everybody got the highlights? Yes, no, maybe so. Okay.
Yeah.
So periodic estates from period to period, it's a lease with a renewal date rather than an expiration date. It'll automatically renew for similar succeeding periods of time as the original lease. Either party can give notice to quit to terminate the lease before it renews. Now, how much notice is needed to terminate before it renews depends on the length of the lease. If it's week to week, 1 week's notice. Month to month, 1 month's notice. If it's for a period of years, 3 months' notice is required to terminate. Now, if a tenant gives their notice to quit, but then they don't vacate, the landlord can ask the courts to hold them liable for double the rent for each month they held over. Listen, the landlord could have already lined up another tenant to move in when you move out. You told them that you were moving out, but then you don't move out. Now the landlord's in breach of contract with that other tenant that was supposed to have moved in. And now they got to put them up somewhere and bear the expenses. So that's why they can hold you liable for double the rent for each month that you've held over. If you told the landlord that you're going to vacate and then you don't. So let's do the highlights now. And cross out the word indefinite under periodic estate because I do not want you to associate the word indefinite with the periodic estate. Even though it makes sense in this sentence, I just don't want you to associate the word indefinite with the periodic estate. That's with tenancy at will is for an indefinite period of time. Let me know when everybody's got all that.
Got it.
Good.
So an estate here, you could do these highlights as well. I want you to associate the word indefinite with a tenancy at will. An estate or tenancy at will is for an indefinite period. No length of time is specified in the lease term. Either party must give 3 months' notice to terminate this. It's terminated automatically on the death of either the landlord or the tenant. And both parties have to agree to the indefinite term with the 3-month notice to quit. Now, when would this be used? Well, it could be used at any time, but it would often be used when a landlord is being notified that the state's taking away their property using their powers of eminent domain. But they don't know when exactly that's going to occur. So in the meantime, the landlord needs to pay their taxes. They need to pay their mortgage loan, right? So they can't exactly get a new tenant in there and give them a 1-year lease because they're supposed to, when the property gets taken by eminent domain, They're supposed to deliver it vacant. So an option is to enter into a tenancy at will with a tenant. You could stay there at the landlord's will or at your own will as a tenant, but either party has to give 3 months notice to quit. So when the state notifies the landlord that of a date when they're actually going to take the property by, they'll notify the tenant, and the tenant has 3 months to leave. Okay. An estate or tenancy at sufferance. A tenant who had a valid lease, the lease expired, and the tenant did not renew the lease and did not move out. They're now a holdover tenant, and they're not paying rent. A holdover tenant not paying rent can be evicted at any time. Anybody who's not paying rent can be evicted at any time with no further notices needed to be provided by the landlord. For non-payment of rent, no notice is ever needed to start the eviction process. That's the only reason where a landlord can start eviction against a tenant without first supplying them a notice to quit whatever lease breaking activity it is that they're doing. This is not squatters' rights, which could create an easement by prescription, though. This tenant was once a lawful tenant with a valid lease. Just as fee simple absolutes the highest estate in land, tenancy in sufferance is the lowest. Because that's a tenant whose rights expired. They didn't move out. They didn't sign any new lease. They're not paying rent. So the landlord cannot remove the tenant themselves. The tenants do still have rights, but those rights need to be revoked by the courts in order to get them out. So the tenant's rights expired. They didn't move out. They aren't paying rent. For every month they remain, they're causing the landlord to suffer. Thus, the tenancy at sufferance name. Right? Make sure you write it here in the book, and also not paying rent. That's an important little part to that. That they didn't sign a new lease, but they're also not paying rent. Because if a tenant doesn't lease expires and they don't move out, hey, as long as they're still paying rent, the landlord could accept the holdover tenancy, right? But if they're not paying rent, every day you stay there, you're causing the landlord to suffer. All right, so a recap on this. The word demise is a transfer of property by lease. A leasehold estate is the tenant's right to occupy someone else's land and are considered personal property, which is an intangible asset. A holdover tenant is a tenant whose rights to occupy the real estate expired, but they did not vacate at the end of the lease term. And there's 4 types of leasehold estates. The estate for years, which need not be for years, it could be, but it's for a specific period of time with a definite termination date. No notice to quit is required because it has that expiration date in it. Periodic estate is from period to period. No specific termination date, but it automatically renews perpetually for similar succeeding periods of time as the original lease. However, the tenant needs to give the landlord a notice to quit. How much notice depends on the length of the lease term. Week to week, 1 week's notice. Month to month, 1 month's notice. A period of years, 3 months' notice. Tenancy at will is for an indefinite period of time. I want you to associate that to get the question right on exams. Hint, hint. Indefinite period of time is directly relational to a tenancy at will. There's no termination date that's needed. It's for an undefined period of time. Either party has to give 3 months notice to quit, though. And a tenancy at sufferance, well, you're a tenant, you got the least rights of anybody. You were somebody who once had a valid lease, the lease expired, you didn't renew the lease, you didn't move out, you're not paying rent, you got no rights other than the right to get the hell out of their house. So the landlord has the right to take you to court so that they could get the court to order that. And then the landlord takes that court order to the sheriff's office, and the sheriff's office can drag you out physically. All right, so what are the essential elements for a valid lease? Well, just like the essential elements of any valid contract, right? You got to have capacity. You need competent parties. A demising clause that says the landlord is to let and the lessee is to take possession of the premises. A description of the premises and what exactly is being rented and what is being excluded from the tenant's use. Because if you don't put exclusions in the lease, say a landlord is renting to you a house. If they don't put in there that, hey, you don't have, this does not include the garage or half of the basement or the attic, then the tenant has access to everything on the property. So if a landlord is going to be putting exclusions in the lease, it's important that they need to write them in. Otherwise, the tenant has access to everything. They're renting everything on the property. The terms must be clearly stated, what the duration of the lease term will be, or if it's at will. How and when the rent paid needs to be specified, because if you don't, the rent is due in the arrears, the opposite of in advance. A little thing that most people are actually unaware of. A lease must be in writing if it's for a term of more than 3 years, and it can be recorded if it's 2 or more. Unless a real estate agent's involved, then it always needs to be in writing, right? And lastly, signatures. Like any contract, it needs to be signed by everybody, not just the landlord or not just the tenant, by everybody. And then it's important to make sure that they get their fully executed copy. I know that landlords a lot of time like to play games. They'll get the tenants to sign the lease, but then they don't want to return it with their signature on it. And it's like, whoa. We're not giving you the money that from the tenant until you bring back and you got that signed lease contract. We need to give them a copy of their signed lease. For some reason, a lot of landlords tried getting away without actually signing the lease. They get the tenant to sign it, but then they don't. I guess they don't want the tenant to be able to enforce the lease terms against them. Anybody know what a window guard is? Nothing in the book about it. This is on page 235, which is one of the pages of the lease contract that mentions it. But there's no paragraph in this book that talks about window guards. And you do need to know about them for exam. So what I did is I just put a highlighted box around section 36 on page 235 of the lease. Or you could snap a picture of the next slide where I put notes together for you. So that's section 36 within the lease on page 235. Or this. So this slide, what you need to know for exams is just what's in the box up top. The additional information down below, well, it's good information to have if you're in the real estate business, but this is all you need to know for exams up top. So what are window guards? Well, window guards are guards that prevent the window from opening wide enough that a child can fall out and possibly get hurt. It applies to buildings with 2 or less rental units. Window guards must be installed by the landlord if there's a child 10 years of age or younger that will be living there or regularly present. If the tenant gives the landlord a written request to install them. The HOAs are responsible for installing window guards in hallways and common areas, and they're only required on first floor units if the windowsill is at least 6 feet above grade. The windowsill is the bottom of the window is at least 6 feet above the ground. Okay, now in buildings with 3 or more units, landlords must install window guards unless the tenant notifies them in writing that they do not want them. It's a little bit the opposite of the 2 family or less, right? They have to install them unless the tenant notifies them that they don't want them. So the landlord needs to get them to fill out that thing that if they don't want them, that needs to be submitted in writing before February 15th of every year. And they must have the tenant fill out a form about window guards. Installed window guards must be inspected twice a year by the landlord between March 1st and May 1st, and again between September 1st and December 1st. And they need to keep a log, a record of the inspection results, you know, if they were loose, if they're tampered with, etc. Now, here's a little miscellaneous additional information for you. If you have a window AC unit installed, the landlord has to use tamper-resistant one-way screws that bolt the AC unit securely to the window frame without leaving any open space greater than 4.5 inches that a child can shimmy through. Oh, the landlords could also charge residents up to $20 for each window guard installed. Okay. If anybody wants to take a picture of this slide, because there's no paragraph explaining this stuff in the book. Oh. All right. So this is what a window guard looks like from the outside of the building. Here's one for those windows that swing out. A window guard can just be an L bracket made of a heavy steel that doesn't bend easy. And here's what it looks like from the inside of the house. You barely notice them. So the window guards have these brackets that prevent the window opening past the window guard. And the window guards themselves do not have any spaces greater than 4.5 inches. And they use those tamper-resistant one-way screws. You need a special tool to unscrew it. All right, so let's talk about the provisions of a lease. In a lease, you have to specify the purpose of the lease, what the property can or cannot be used for, or what areas of the lease of the property can or cannot be used by the tenant. Now, as far as specifying what a premises can be used for, that pertains more to commercial real estate. You know, it's a really important thing to be putting in commercial leases, but we don't prepare those leases. We only prepare the non-binding term sheets for them and then have the attorneys write up the lease. So it's really important in commercial leases to specify the use of what the premises can be used for, because if you don't specify it in the lease, then the tenant can use it for any lawful purpose. So let's just say they started renting from you to have a convenience store, and then they change their mind because the convenience store business isn't doing well there, and they turn it into a daycare. You know, as long as it meets the zoning requirements and the city's okay with it, well, the landlord cannot object to it. The property can be used for any lawful purpose. That's why most leases in commercial specify a specific use that it can or cannot be used for. Let's take an instance why this would make sense, why it's important. Take a look at a strip mall. Say you put a pizzeria in a strip mall, or a nail salon in a strip mall. All right. They're the only one there. They're making money. But if another tenant moves in and opens up another pizzeria or strip or nail salon, whichever scenario you want to go with, now you're going to have two tenants struggling for the same clientele in the area. And now you got two tenants that are going to be struggling to pay the rent because they're fighting for the same clientele in the area. So you really only want to have one business of each kind in that strip mall. Otherwise, you're kind of shooting yourself in the foot as a landlord. You're going to be dealing with tenants that are going to be struggling to pay the rent, and that's not fun. Nobody likes evicting anybody, but if they're not paying the rent, it is a business. You got to get out so that we can get someone else in. And we know you put a lot of money in trying to fix up the place and prepare it for your business purposes. the down payments, the security deposits and all that. Nobody wants to evict you, but hey, if you're not making the money, not paying the rent, you got to go. And New Jersey requirements that the agency relationships be disclosed in any leases. We also need to give that CIS form to anybody for residential lease transactions more than 125 days. The opinion 26 notice needs to be the cover of the leases prepared by licensees as well. What's the purpose of the opinion 26 notice? Tells you that you have the right to hire an attorney, right? So obviously this does not need to be the cover page of commercial leases, but it does for residential, because we don't prepare commercial leases, so the attorney's already involved. We just need to have the opinion 26 notice be the cover page of any lease prepared by licensees. So that'd be for the residential properties.
Can
And
you
of
go back
course,
real quick? Just
go
for
ahead.
seconds. I just want to screenshot.
What happened? You want me to go back
Just one. I just want to screenshot
to this one or a previous one?
to that.
Okay.
Got it.
Okay. So the federal lead paint disclosure, we need to have a blurb about that within our lease contracts, and we do. But the actual form is separately provided to tenants if the property is built prior to 1978, just like with the sales contracts. Tenants need to be informed about any possible lead in the property, or specifically lead paint. According to federal law, the owner needs to disclose the presence of any known lead hazard in the property and provide that lead disclosure statement and the booklet, Protect Your Family from Lead in the Home, and a 10-day opportunity to conduct an inspection or waive that opportunity if you want to close on the lease any sooner. And then, of course, now New Jersey is not going to be outdone by any federal law. So we create our own laws pertaining to this, and this one actually requires an inspection, whereas the federal requirement for the disclosure of any known lead hazard does not require any inspection by anybody. It just gives the opportunity for the renters or buyers to do an inspection. Here, New Jersey's lead safe law requires that landlords have the city their property registered with the city as a rental and have it inspected and certified lead-free. That went into effect July 2022, the New Jersey's lead safe certification. So you're going to register it with your city. Each municipality had to put a process in place to do this inspection. And you pay for a permit and you pay for the inspection and yada, yada.
As a realtor, are you going to rely that the homeowner goes to the township to get the permit to rent the premises, or you
need to make sure that they did, or
They
do
did.
it for them. Yeah,
Okay.
because you're going to need to provide it. All right, security deposits. Let's talk about security deposits. I got a whole slide here on security deposits, so let's talk about it a little bit, okay? What is security? What's a security deposit used for? Well, it's used to guarantee the payment of rent, but it's also to cover damages that a tenant may do. The money must be placed in a special interest-bearing account, because that tenant would have normally had their money sitting in their interest-bearing savings account. So the landlord has an obligation to put the tenant's security deposit in an interest-bearing savings account that's used only for security deposits. They need to notify the tenant where it's being held, their money, and how much, and they need to be notified what interest rate they're earning and be supplied with the interest. So the money that is earned off of their money, that interest, has to be credited to that tenant on the anniversary of their lease. If the landlord does not do this, the penalty is double the entire amount of security that's being held. So if the landlord doesn't pay you out those couple of pennies that your security deposit has earned interest on in the bank, and the tenant knows their laws, they know the rights, they could take the landlord to court and ask the court for the landlord to be required as a penalty for not paying them their interest on the anniversary of their lease to pay them double the entire security deposit. And what's the maximum security deposit allowed for residential real estate? 1.5 times the monthly rental figure. There's no maximum security deposit fixed by law for commercial real estate. Can a landlord charge pet security? Sure, as long as it does not exceed the 1.5 times total monthly rental figure for the security deposits that are already on file. So if the landlord already has 1.5 security, no, they cannot charge any kind of additional security, like pet security or payment of rent in advance for the first and last month's rent, which is still considered security under the eyes of the law. Service animals, well, can you charge them fees like rent or a fee for having a service animal? No. Can you charge them security deposits? Sure. Just don't call it pet security. It's security. The maximum you could get is 1.5 times. And if that service animal causes damage to the premises, the landlord can always chase after the tenant for those repairs if they exceed the rental security deposit. All security deposits have to be returned to tenants within 30 days of their lease termination. If there are no damages, the penalty for violating this rule is double the security deposit. What do you do if a tenant moves out and they didn't tell you where they were moving? How do you return the security deposit to them within 30 days? Anybody? You send it to their last known address, and that's the apartment that you were renting to them. They may have forwarded their mail, then just didn't tell you about it. And if it comes back undeliverable, well, don't open it up. But you could go to the court and ask the court if you could keep the tenant's security deposit because they didn't put a forwarding address on there and maybe they did some damages or something. I don't know. But either way, damages you could have already deducted anyhow. So what do you do with that security deposit? You could send it off to New Jersey's unclaimed property page, right? Now, deductions for damages must be on an itemized report. You can't just say, hey, I'm keeping your security because you effed up my place. You can't do that. You got to give them an itemized list of what the damages are. There was a hole in the wall over here that needed to be patched up, and this is how much you were charged for it. This was damaged, and this is what you were charged. There were stains in the carpet, and we tried to clean it. We were unable to clean it, so the carpet needed to be replaced. So this is the charge, and you're probably not going to get any of your security deposit back if that happens. There was a lot of garbage and rubbish left behind. They could charge you for that, for the removal of it and disposal of any furniture or garbage or trash. What about if they were smoking in the apartment? Can the landlord charge the tenant damages for odors?
Depends on the rules of the lease.
Well, odors, they can. I mean, look, even if you got the rules of the lease that allow you to smoke, if there's a stink of smoke in that apartment, you can be charged, whether it's cigarettes or marijuana or whatever else it was you were smoking in that apartment, right? The same thing applies to people who use strong spices when they cook. You know, he, I remember I had this one guy. I was going and I was showing his place for that he was selling. He was selling his condo, and I was showing the apartment, and the person opens up the closet door to look inside, and they see all of his clothing that's hanging from the hangers. They're all in those plastic zippered bags. Now, some people do that to keep their stuff clean. The owner was there, and I was like, "Wow, you're really organized here, huh? You got everything in its own little bag." And he's like, "Well, we're Indian, we put curry in everything that we that we eat, and it's a strong smell that gets into everything. I don't want everybody smelling that when I'm at work. So he puts all of his clothes in those plastic bags so that his clothes don't smell like curry." And I was like, "Okay, yeah, I understand." Um, so can a landlord charge you damages if you always cook those with strong spices that leave a smell in the counters, in the cabinets, in the walls?
I believe so because then you have to get someone to come deep clean, like fully deep clean the house in order to get all those odors out.
Yeah, yeah, that's true. It's true. Listen, sometimes you deal with bad tenants too that they just don't give a shit, right? I mean, I had somebody with a bad tenant. We needed to kick them out. I mean, I showed you already the pictures to that apartment where there was holes and everything, piles of garbage everywhere. We got them out eventually. But then they went a step further just to be an extra layer of scumbag. There was an awful smell. Once we got that place all cleaned out, there was a horrid smell. We couldn't figure out where the hell it was coming from, but there was a horrid smell in the apartment. Um, this was a two-family house. And I'm going through because I got a pretty sensitive nose. So I step out of the room and I walk in and I'm like trying to track it down like a dog. Where's that smell coming from? And I narrowed it down to a closet, and I'm looking in the closet, and like, closet's empty, closet's clean. It smells coming from this room. It's definitely coming from here. It's the strongest here. So I got a step ladder, and I looked up top in the closet. You got the closet, then you got that top shelf above the hangers and stuff. There's a shelf up there. There's nothing up there. But I noticed the tenant punched a hole in the wall in one of the corners behind the top shelf at the bottom by the shelf, punched a hole in the wall. And that's where the smell was coming from. They loaded it up with dead fish. Yeah, yeah. People do stuff like that. It's unexplainable. It's just trash. Unfortunately, some people are just trash. They don't care about anybody's property. They only care about themselves. And even when they're the one that's the problem, instead of realizing that they're the problem and they can't really blame the landlord for why they're evicting them, they go and they pull crap like this and say, "Screw my landlord. My landlord's a jerk off." Well, no wonder they are. Who could blame them? Look at you, the tenant, acting like this. That was crazy. So they had to break out the sheetrock wall and clean out all the dead fish from behind the wall. Oh my God, that was nasty. Anyway, moving along. So if a property is sold, then the landlord must turn over security deposits to the new owner and then notify the tenant where they're being held, because now that new owner of the property is going to be responsible for returning the security deposits to the tenant when they move out if there are no damages. Okay, so here I summarized all of these security deposit issues on one slide for you. If you wanted to snap a picture of this slide, pretty good note. So we can highlight this stuff for security deposits in the book. Right?
One sec.
Sure.
Yep, done.
Staining my lips red here. I'm drinking pomegranate. Pomegranate mixed with blueberries, though. It's pretty good. Everybody got it? All right. Late payments. When is the rent due? Well, depends what they write in the lease, right? If the landlord doesn't write in the lease, it's due at the end of the month, the arrears. Now, most landlords write in the lease that rent is due on the 1st, but certain tenants have to be given a grace period of at least 5 days free from any late fees or penalties. Those are people who are relying on Social Security benefits or old age retirement, railroad retirement pensions, or any other government or quasi-governmental pension or payment. Because if the government is late in sending you the check, the landlord cannot penalize you for that. So these people who are receiving payments from these sources have to be given a 5-day grace period free from any late fees or penalties. And most landlords know the law that they need to give certain people 5-day grace period, but they're not exactly sure who or why. So they give it to everybody usually. And then after that, they can start charging late fees and penalties. But remember, check with your local rent control laws if your municipalities have them. Not all municipalities do, but municipalities that do have rent control laws, which these are well-meaning laws meant to protect tenants from abusive landlords. However, it's a double-edged sword, cuts both ways. You get a lot of people who don't want to develop in towns that have rent control laws because they won't be able to keep up with the buildings over time as they start to age. For that reason, New Jersey also passed a law that landlords are exempt from rent control rules in municipalities that have rent control laws as long as there's still a first mortgage on the property. All right, so there's that. And we can highlight it here on page 239 about the 5-day grace period for those folks. All right. The legal principles of a lease. The possession of leased premises. The tenant cannot take possession until the dates specified in the lease come about. Do not give a tenant ever access to a property, even just to put a few things in before the lease inception date. Because they could put one bag in there of their belongings. Under the law, they've taken possession of the premises already. And then if they should not be paying the rent or anything happens, any problems happen there, guess what? Landlord got to go through the eviction process to get them out. They got to go through the courts. And you're going to have a problem when somebody reports you to the real estate commission. So make sure you do not give anybody unaccompanied access or allow them to place any belongings in a premises, even that they signed a lease for, before the lease inception date when it's supposed to begin. Remember, we need to get city inspections done first before a tenant can move in. Any rental property, before a tenant can move in, it needs to be inspected by the city. They want to make sure that it has all the carbon monoxide and smoke and fire detectors, and even the fire extinguishers if still required by your municipality. I know our governor, for no apparent reason, he's like doing all kinds of crap on his way out the door, raising taxes, changing laws, and doing all kinds of wacky stuff without reason on his way out the door here in this before the election that's coming up. And one of those things was inexplicitly, he removed the requirement for fire extinguishers that are required to be in the kitchens, the ones under 10 pounds, rated to put out ABC type fires. Well, he removed the state requirement for that. However, your local fire officials may still have that as a requirement. So even though he removed it as a state inspection requirement, your local municipality may still have that restriction. So keep that in mind. Licensees should never give a tenant keys, even to only put a few of their belongings in there. That's what I put here. You'll be risking your real estate license by doing so. We all saw about this guy already, so I'm not going to play this video again. We played this in Chapter 4 under discrimination, where a landlord let the tenant or the landlord's employee used his pass key to enter a tenant's apartment. And there was no emergency or no prior appointment and no reason for them to be in that apartment. He just used it to start perusing around through the tenant's fiance's underwear drawer and doing lewd things to them. And he went to the police department to try to see what could be done about it. And they said they didn't do nothing illegal, which is totally false, because that landlord's agent is not allowed to use their pass key just to enter an apartment. They need reason to. They need an appointment or they need permission, unless it's for an emergency. Gas leak, water coming out from under the door, something of that nature. Short of that, they cannot enter the apartment. That's breaking an entry. So, under the criminal code of defiant trespass, and remember I gave you guys that Truth in Renting booklet? There you go, right of entry. Landlord shall be guilty for an unlawful entry and detainer if they enter the rental premises without the tenant's permission, even if they're not at home. All right. Improvements. Can you do any improvements to an apartment as a tenant? No. You can't even paint the apartment without the landlord's written permission. They want to make sure you're not going to be painting it some wacky color, like painting your room a dark purple or hot pink or black. These are some unusual colors, but people do weird things. And these colors are usually hard to cover up. So, yeah, if the landlord does give you permission to paint it and paint it whatever color you want, they're also going to require you to paint it back before you move out. Otherwise, they'll take it out of your security deposit and they'll have you sign an agreement stating as much, that you agree to paint it back like a neutral egg color, like the other eggshell color. Otherwise, they're going to take the money out of your security deposit to get it painted. So doing any other improvements, like changing light fixtures to ceiling fan lights and things of that nature, you would need the landlord's written permission to do that. And they're probably going to say, if they grant you that permission, they're going to say, yeah, but you need to get a licensed electrician to do it. We don't want you getting electrocuted and then being held liable for that, or you burning down our house, right? The rental unit. So if the landlord does give you permission to do improvements, can you take that ceiling fan light fixture with you when you leave?
You'd have to replace it.
Yeah, you can't take it with you unless you get the landlord's permission to, right? So if you got the landlord's permission to install it and they gave you permission to take it with you when they leave, they're going to want you to replace it with something else, like you said. Or most people don't do that. They just try to get the permission to install it. Then later on, they want to take it with them. And if they do just take it with them and they don't replace it with the same thing, a landlord could say they caused damage to the unit. But I put back the light fixture that was there. Well, we didn't give you permission to do that. We gave you permission to upgrade it. We didn't give you permission to downgrade it. So a tenant would be in breach of contract, and the landlord could withhold security deposit to cover that fixture removal. All right, trade fixtures. These are fixtures that are used for business purposes, and they're considered personal property that can be removed by the tenant as long as they remove that personal property before the lease expires. If the lease expires and they didn't remove that trade fixture can become a fixture and part of the real estate. Okay? So let's write above there where it says something improvements. Where's that? Page 240. It says improvements. Just says improvements over here. Write trade fixtures above that and write tangible personal property / chattel. And then you'll highlight, it is customary to provide that such fixtures may be removed by the tenant before the lease expires. Of course, provided that the tenant restores the premises to their same condition as when they took possession. Okay. Trade fixtures, tangible personal property / chattel, and then highlight that sentence. We all good? All right. So leases carry with them an implied warranty of habitability, meaning that there is no condition that is present that could cause the threat to the occupant's health or safety. In other words, it's in habitable condition. The tenant must return the premises in the same condition that they received it. The landlord's responsible for repairs unless specifically specified otherwise in the lease. Tenants are responsible for any damages they do. The DCA, that's the Department of Community Affairs there in Trenton, they inspect buildings with 3 or more rental units, not counting the unit that the landlord lives in. So if it's a 3-family house and the landlord does not live in it, then state inspection needs to be done in that building. If it's a 3-family house and the landlord lives in it, then it does not. The local inspection will take place. If it's a 4-family house, doesn't matter if the landlord lives in it or not. There's 3 or more rental units available, so that building requires a state inspection at least once every 5 years. The industry lingo, what we call that inspection, we refer to it as the green card inspection. Has nothing to do with immigration. Okay, we call it the green card inspection because when you passed inspection, they gave you a pass certificate and the color of it was green. Okay, so even though now they pretty much give it to you in PDF format that you download it and print it yourself now, they don't give it on that specialty paper anymore with that water ink marking on it. So it's no longer green, but we still refer to it as the green card inspection, at least some of the old timers. Now, so familiarize yourself with the industry lingo there. Now, if rent is withheld by a tenant, to force the landlord to make necessary repairs due to uninhabitable conditions, dangerous conditions, it should be placed in an escrow account to pay the landlord later. All that back rent that's been withheld after the repairs have been made. The whole purpose of withholding that rent is to force the landlord to do the repairs. Or the state of New Jersey does recognize the tenant's right to repair and deduct from the rent, but this would require the tenant to try to save the landlord money by getting at least 3 price quotes, legitimate price quotes, not from a couple people as contractors that give inflated price quotes. Otherwise the landlord can say, nope, screw that, I'm evicting you, I'm taking you to court, and the court will take a look at those price quotes that you gave and see if those are reasonable averages for costs for certain repairs. Okay? They're not going to honor ridiculously high inflated price quotes just to take advantage of the landlords. So let's do the highlights under implied warranty of habitability. We're going to write here about the green card state inspection and how often that's done, at least once every 5 years. And here's just a paragraph about doing repairs and New Jersey recognizing the tenant's right to repair and deduct. The tenant may withhold rent until the repairs have been made, or if repairs are vital and the landlord does not make them within a reasonable time. Like, what is reasonable time? Well, if you got a leaky roof, how long would it take you to call up a roofer and get a roofing company to come in and do the repair? I mean, if it's the peak of the roofing season, it may take a little while, but at least you could get them to come out and put a tarp on the roof, Well, you got to extend that same courtesy to a landlord. You can't hold a landlord to unreasonable expectations either. So, but the tenant can have the repairs done and deduct their cost from the rent. If the rent is withheld, it should be put in an escrow account or keep it somewhere that you have it handy. Such measures, especially to claim constructive eviction, should not be undertaken without consulting an attorney first. Okay. So constructive eviction is when the landlord fails to make necessary repairs that are dangerous conditions. The tenant can use that as a reason to legally break their lease early and not be in breach of contract. We'll get into that. We'll have another place that specifically talks about that and highlights that in the coming pages. Now, this all the way down at the bottom, I just put a little asterisk next to it. I don't think it's on exam anymore, but I don't know. I haven't heard any students come and tell me that they've seen it on exam. Used to be on exam. When the landlord furnishes heat, because heat's included in the rent, between October 1 and May 1, all rooms must be heated to at least 68 degrees from 6 a.m. to 11 p.m. and to at least 65 degrees at night. Now, I had a student one time snap out really quick and say, that's cold, that's freezing. No, it's not. Freezing is 32 degrees. All right. That's the law. Hey, you know what? In buildings, where the landlord is supplying the heat, if you're not paying the rent, you're lucky you're getting that. But look, even in buildings where the landlord supplies the heat, and you are paying your rent, a lot of times these buildings make it very difficult. It's for the tenants' heat to be controlled. Everybody gets the heat, and I guess those that are closer to the boiler room get the best heat, and the further you get away from it, and maybe a little bit more lacking. You guys have all these notes and little notations here and stuff? Okay, that's quick. You guys are quick at kicking your notes. All right. So I just have this slide once again about the green card thing. So state inspection often refers to as the green card inspection. That's the industry lingo, not the official name. It's required for any building with 3 or more rental units, not counting the unit the landlord lives in. So the DCA, that's the state inspectors, come in and do the inspection on behalf of the state there. And those guys are anal. They find problems with new construction. The state inspection must be performed at least once every 5 years for buildings with 3 or more units. So if you're selling, or you got a client that's buying a building with 3 or more units, it's important to make sure that the landlord had that inspection recently. You want to get them, you want your client to buy that house and make sure that that inspection certificate showing that it passed the state inspection is up to date. Because if it's expired or very close to that date, you should demand that the seller get that arranged for that inspection to be done. So now that the buyer knows that there's not any major repairs and work that needs to be done, and if it is required, the state's going to make the landlord do it. So this way they get that building and they don't have to jump into the money pit now doing all kinds of repairs that are required. Hotels and motels require inspections once every 3 years. And those inspections can be done without an appointment. They can be spot inspections. Landlords must maintain temperatures no matter if the tenant is paying rent or not. Like I said, between October 1 and May 1, 68 degrees at night. Between 6 a.m. and 11 p.m. and at least 65 degrees at night. Sorry. And the landlords cannot turn off the heat, the hot water, gas, or any services that may be included in the rent, even if the tenant's not paying the rent, as a means to try to get them out. That's like changing their locks or going in their apartment and throwing all their stuff by the curb if they're not paying the rent. It's basically a way of trying to do an eviction on your own. And can you evict a tenant? No, only a court can. Remember from the last chapter 11, novation, assignment. Well, here we got it again. Assignment is where a tenant transfers their lease obligations to another. However, the original person named in the contract is never relieved of their contractual obligations if that tenant who's subleasing does not pay the rent or follow the rules of the lease. Novation would be a way to get them to be relieved of those further obligations. They can novate the contract, substituting the old contract with a new one, so only the new one can be legally enforceable. Or they could do novation of the parties and only substitute the persons named in the lease or contract. Subleasing usually is restricted, at least per the leases that we prepare. They say tenants are not allowed to sublease, not unless they get the landlord's implicit written permission to do so. All right, and of course, tenants are responsible for destruction of the premises. Okay. Notice to quit. This is just the timelines for the different types of leasehold estates. How much notice is needed to be given to terminate an estate for years? No notice because it has an end date in it. Tenancy at will, 3 months. Periodic estate, well, it depends on the length of the lease term. Week to week, 1 week's notice. Month to month, 1 month's notice. An estate from year to year requires 3 months' notice. So that's on page 241, that bulleted list towards the bottom of the page. All right, the truth in renting booklet needs to be given to tenants in buildings that require that state green card inspection once every 5 years. And which buildings are those? The ones with 3 or more rental units, not counting the unit the landlord lives in. Now, the truth in renting booklet can be given to anybody, but it's only required in these buildings. So what is that truth in renting booklet? Well, the DCA publishes the annually updated statement on the rights and duties of residential landlords and tenants in the form of a booklet, which is no longer printed. They make it available to you in PDF form, and you can print it on your own. It applies to residential properties requiring the state green card inspection. It's required to be given to tenants in buildings with 3 or more rental units, not counting the unit the landlord lives in. That includes mobile homes. Does not apply to commercial real estate. And you can find those statements right here on the DCA's website. It's available in English and Spanish. Okay, so here's a direct link to it in English. And here's a link to the DCA website where you can get it in English or Spanish. And you can get the interactive booklet there too. Okay. So beginning March 20th, 2024, every landlord must provide a notice to prospective renters, including whether the rental property is located in a FEMA special flood hazard area or moderate flood hazard area, and they have actual knowledge that the rental premises or any portion of the rental premises, such as tenant parking spaces, have been subjected to flooding in the past. So landlords may print a copy of the Truth in Renting booklet and the flood risk form notice from the DCA's website. Oh, let me give you that. I gave you the other links. Let me give you the flood risk notice now. And I guess here's where you'd highlight it in the book, but the book writes everything in a backward, weirdly worded way. So I had it written at the top of the page. Truth in Renting booklet must be given to tenants in buildings requiring a state green card inspection with 3 or more units, not counting the unit landlord lives in. So let's just highlight Truth in Renting. The act requires residential landlords of dwellings with, I forget what it actually said in the book. I whited it out, and I just wrote 3 units or more if the landlord occupies one of the units, to distribute the Truth in Renting statement to each of their tenants prior to the tenant's occupancy. That's on page 242. So yeah, the way the book words it underneath here is they say the act requires residential landlords with dwellings with more than 2 units or more than 3 units if the landlord occupies one. So 3 or more units available for rent. Okay. It's weird that they wrote more than 2 units because more than 2 units is 3 units, right? So why not just write 3 units, the number 3? Or more than 3 units, so 4 units or more if the landlord occupies one. Told you the book words things really strangely. That's page 242, right? I already got a note about that. Let me know when you got the highlights and the notes and the changes. Okay. Okay. Okay, you got to disclose the names and contact information for the owners or property managers to your tenants, as well as to local governmental agencies, so they know who to contact in case of emergency, like if the building burns down or explodes, like they did in Hillside the other day. You guys see that on the news yesterday? Federal crime insurance. We got to notify the tenants that subsidized crime insurance, it's basically renter's insurance, is available at a cheaper price. So I don't know how much cheaper it could get. I think it's like $100. You could get renter insurance for like $100 a year. You could get renter's insurance that'll cover like $60,000 worth of your belongings. So I don't know. But either way, we got to notify in high crime areas the tenants that subsidized crime insurance is available through HUD. And then the ADA, the Americans with Disabilities Act, was created to prevent discrimination in the workplace against persons with disabilities. This has to do with commercial properties. Title III of the ADA prohibits discrimination in commercial buildings, require them to be handicap accessible. It says that all new construction must be handicap accessible because it's easier to construct a building and have it handicap accessible than to go in and modify an existing structure. It could cost a lot more to do that. And it may not even be possible in some instances. So for an existing structure, the ADA recommends reasonably achievable accommodations to provide equal access to the facilities and their services. Reasonably achievable accommodations means with low cost without massive retrofitting or remodeling. Now, it may be useful to consult with an ADA expert and architectural engineers or designers. Okay. And here's some examples of reasonable achievable accommodations. Lowering wall-mounted payphones, if you could ever find them anyway. Lowering water fountains or installing a cup dispenser as a workaround instead of lowering the water fountain for somebody who's in a wheelchair. Changing the direction in which doors open. Adding ramping, changing door handles to push bars. Installing auditory signals and braille buttons in elevators. Making handicap parking spaces available for people with disabilities when appropriate. So let's do those highlights in your book. Okay, so this is on page 242 and 243. Everybody get the highlights? Are you still working on it?
Good.
Okay. And we went over and we discussed service animals already and how that works. So let's just highlight here this about the service animals, and only two questions may be asked. Is the animal required because of a disability? And what work or task has the animal been trained to perform? Title 2 and 3 of the ADA, service animals are limited to dogs. However, entities must make reasonable modifications and policies to allow individuals with disabilities to also use miniature horses if they use them instead. Of course, they need to be housebroken. Otherwise, that could be a pretty messy situation. Now, when it comes to residential properties, service animals, doesn't matter if it's a service animal or if it's an emotional support animal, they need to allow a reasonable accommodation for them. With just a letter from the therapist or doctor saying that it's needed for the disability of the person.
I have a question regarding this. We have a lot of tenants so we have a no pets policy at most of our properties. A lot of tenants have been getting what is not a service animal like certificate, but emotional
Emotional.
support
Yep.
animals. And it's not a very clear definition, right? Because some people are getting these, let's say, like on the internet, people are paying like $10 for a certificate, and then they say, I
There's a
have
lot.
this emotional
There's a
support
lot.
animal. Do I need to permit those animals?
Well, first of all, there's a lot of fake websites out there. Okay.
Right.
So what do you need in order to provide what's known as a reasonable accommodation? You got to think of the service animal as a part of as the person's disability. Okay. It's like a wheelchair that somebody who can't walk would need. Okay. So you got to think of it as part of a person's disability. But there are people out there using these fake websites trying to get their animal registered as a service animal and such. And so what do you need? Well, you need a letter from the doctor or therapist with on their letterhead that states that you need this they need this animal as a service animal or emotional support animal. And it has to have their contact information, like the phone number of the doctor and their address on the letterhead, so that you could call up to verify that it is a legitimate need.
Is it on me to prove that it's not legit? Like, for instance, we have one tenant that has two dogs that she claims they're both
They're allowed.
emotional support.
They're allowed two emotional support animals. Yeah.
Huh.
But I thought it was one dog or two cats. I guess it could be two dogs too. But yeah, for emotional support, they're allowed two, and those animals don't require any kind of special training or anything. But the service animal, that's one where like a seeing eye dog or one that helps somebody if they got
Right.
seizures or
That we are
low blood
clear
sugar.
on. It's
Yeah.
just this because people literally are just
Well, it's the same kind of requirement for it though. they need a letter from the doctor or therapist on their letterhead with their contact information. And then you could contact that doctor or therapist to just confirm that they do have a legitimate medical need for the animal. And you could require that they provide a new updated form every year. Because
Okay, so it's good for 12 months at a period.
yeah, they may not
Okay.
need it. It's like a prescription for medicine. They may not need it next year, you know?
Okay.
So
Thank you.
you're welcome. All right, so when it comes to rental referral agencies, we went over this in the end of chapter 1. What is a rental referral agency? These are these agencies, the agents that go to apartment complex owners and that already have their own rental offices. And you go to the owners and you talk to them and say, listen, we'd like to market your property. We'll put together a nice floor plans. We'll put a web page together for you. We'll highly advertise it. And in the event that we get a renter for your apartments, you're going to pay us a referral fee. Okay. If anybody enters into a lease for one of your units. Now, some of these brokerages, they just have their own rental offices. People walk in off the street and they help them find properties in their listing inventory. So if the property's listed but not advertised, they need to check every 3 days to make sure one of those units are still available. If it's advertised, they need to check every day with the property owner to make sure one of those units are still available, because they may have many different units with many different styles of studios, of 1 bedrooms, of 2 bedrooms, of 3 bedrooms, etc. Okay. So if advertised, we need to check every day to see if a unit's available. And if it's just a listing, but not advertised, every 3 days. One example of this is bestrentnj.com. That's why I got them here, so we could show you their website and how they work. This is what these rental referral agencies do. Now, anytime a tenant gives you advance fees of $25 or more for whatever reason, it needs to be held in the escrow account. So you guys can do these highlights here on page 244. Advance fees of $25. Regulations require deposits in the depositing of those funds in the escrow account. Units that are advertised must be checked every day to see if they're still available. Units that are simply listed must be checked every 3 days. Now, if you go to Best Rent NJ's website, this is what these rental referral agencies do. They have you can look up properties, all right? Let's see. They're showing you a bunch of their buildings. Look, here's a 55 plus community. Okay, now open. They got a lot of new ones that actually the developers go directly to them. The station at the Village, at Avenel. Yeah, these look like they're all newer ones. Well, Harbortown Bay, that's not newer, I don't think. No, it is. Okay. All right, let's see. Do they have any other ones here that you can look up? Because they got 85 communities. So let's click on there and see some of the other ones in the area. Let's look at Edison. Edison's got a lot of older ones. Okay, so they got some new ones. This is an older one, Edison Village. Okay, so let's click there. Let's check it out. So they tell the apartment complex owners, hey, listen, we've got, we're going to take some high quality photography. We're going to put slideshows up and floor plans. We're going to talk about the features, like here's the community house for the pool. Some nice features of some of the nicer apartments they'll probably take, or condos. And they'll show you here. They got different layouts, like the 1 bedrooms. Look, there's 1, 2, 3, 4, 5 1-bedroom, 1-bathroom units available with different layouts for different prices, different square footage. And then there's additional 2 more that also include a den, 1 bedroom, 1 bath with a den. So what they'll do is they have all the different prices here laid out, and they'll show you floor plans that they draw up and put on their website as well, right? Different floor plans so people can see the floor plan layouts of these units. So that's what they do. They make up all these all these and they put it on their own website. Whether they put it on the MLS or not, usually they just got them on their websites here, and then anybody who's interested, they get their own renter, and then they get paid a referral fee. Then they write up, all the different apartment features and amenities in the area.
And
They
they
talk
charge
about the,
uh, and they charge the application fee?
sure, they could charge an application fee. I don't know if they do, but they could. All right. Then they got maps showing you everything that's in the area and nearby. If you want to look up specific other properties, transportation, restaurants, schools in the area, etc. So that's their thing. They only deal with rental properties. They don't deal with properties for sale. They specialize in rentals. They go up to big apartment complex owners and they do this. Whereas most real estate agents, they don't go to apartment complex owners, maybe 1 or 2 family or even 4 family houses really for rentals, but they don't really approach the apartment complexes because they know they got their own rental offices and all that. Well, these guys, they don't care. They say, hey, listen, we're going to put together, look at these slideshows. We're showing all the amenities, the exercise rooms and all kinds of other features of the complex. We'll put up a web page just dedicated to your complex here. And then we'll advertise the hell out of it on our high traffic website. Their laundry room. Oh, it looks like it's pretty modern here now. Look at that. Nice little rest area outside. Really? Where's this? Older apartment complex too. It's not bad. Maybe they're just making it look nicer than it is, right? But they make it look really nice there. And if anybody decides that they're going to rent, well, then they can. See, this was originally apartment buildings. I think they converted them to condos and they started selling them, but I guess they rent out a bunch of them here too. Edison Village. I'm trying to remember that. Brunswick Avenue. Huh. But I tell you what, for a 2-bedroom, 1.5 bath, $2,900 a month, I'm going to try to convince you to buy a house. These rents are getting crazy. But I tell you what, if that Mandami, socialist, communist guy decides that he wants, he gets elected in as the mayor of New York, we're going to be seeing a lot more New Yorkers moving to Jersey, and prices are not going to be staying down or going down anytime soon, because that's that much more housing that's going to be in demand in New Jersey. And those New Yorkers got more money than they know what to do with, because what they currently spend on rent is way more than what we do. And so they're willing to spend more on it. So the cost of housing is not going to get any cheaper here. All right, so rent control, I told you, not all municipalities do have rent control, but those that do, you got to make sure that you are evicting tenants or raising rents. You need to comply with whatever the local rent control rules are, or for holding tenants responsible for damages, etc. So these are rules that are set by each municipality if they have them. Now, I put a note here that licensees should be careful when showing rental properties for sale to investors. They should use caution before telling them that the rents are low or below market rates, and they could always be raised. Oh, there's a good price on this building. Look at it. How much are they charging for rent here? Oh, those rents are pretty low. Yeah, that's below market rates. You could always jack up the rents on this and make some money. That may be the reason why they're selling it. It may be in a town that implemented rent control. And if they got rent controls, they may be restricted on how much they can raise the rents, if at all. So that's why the landlords are getting rid of the buildings. That's the issue with rent control. It's a well-intentioned, a well-meaning law that's passed to try to protect the public from bad landlords, that take advantage of tenants. But it has a double-edged sword to it. because they may be restricted on charging tenants for damages or for increasing their rents, and they can't keep up with the cost of living. And then it's that much thinner margins for them to be able to do improvements and maintain the building and make a living off of it, because that's, after all, the landlord's intention for having rental properties, right? They're not there just doing this because they have an obligation to provide housing to everybody. They're doing it to make a living. And if they can't, it may make sense to get rid of the building altogether, cash out, you know, and then that's what they do. So be careful with your puffing when it comes to selling rental properties in towns that have rent control. Be careful what comes out of your mouth, because if you tell somebody, oh, you can always raise the rents, and then it turns out they get rent control and they can't, you may have issues. So here's a statement on page 245 that talks about that. It says, although rent control clearly benefits tenants, many argue that in the long run it can hurt them, because it could discourage investors from putting up rental housing and can cause hardships to landlords who can't bring rents up to fair market value, encouraging them to let the buildings deteriorate and eventually be abandoned even. All right. So, who cannot be evicted from a condominium conversion? You know, you buy an apartment building, you convert it to condos so that you could sell each unit. Well, those that are 62 and older, or certain disabled persons who lived there for at least 2 years before the conversion began, and their income is no higher than 3 times their county's per capita income, or in any case, no more than $50,000 a year. If they meet all these requirements, they could remain as tenants for the next 40 years, and you cannot evict them so that you could just convert them to condos. Yeah. So let's do the highlights that say that same thing on page 245. And right there in the margin, condo conversion evictions. Okay. So here's a different type of eviction. It's called constructive eviction. We kind of mentioned it in passing recently in one of the previous slides. What is a constructive eviction? Well, it's when the property has uninhabitable conditions due to the landlord's failure to maintain or make repairs. The tenant can claim constructive eviction. So it's an action that's taken by the tenant to legally terminate their lease early if the landlord fails to provide basic services or make essential repairs when there are uninhabitable conditions. The tenant has to notify the landlord that there's a problem, number one. They're not mind readers. And if they don't fix it in a reasonable amount of time, and they keep ignoring all your requests for repairs, the tenant can vacate and move out, and then stop paying rent after they move out, and then notify the landlord that they're terminating the lease early due to constructive eviction. Seek legal advice before doing this, and the landlord has to return all the security deposits to the tenant. So here's an example where I had an issue with this once. I had a listing from this landlord. It was a one-family house that was grandfathered as a two-family house, where the basement was an additional apartment because he had this little doorway and stairs going down to it. However, in order to keep it as a two-family house legally for rental, he had to keep the lock to the stairs that go upstairs between the two apartments unlocked. So it has two exits. But that door was always locked, it just unlocked for inspections. Anyway, the tenant moved in here and she was a single mom, newborn baby. And she liked it. It was good enough for her, so she liked it. A couple months later, she calls me up, Vic, I got a problem. What do I do? What's the problem? Well, the landlord's usually very responsive when I call him, but he doesn't respond to calls. He likes text messaging and email, but he's very responsive. However, he's not been responding to me lately. Well, what's the problem? Well, I first noticed this when I was bathing my baby in the tub. You know, we put the baby in a little plastic tub and then put that inside the tub, and I bathed the baby. And I was like, okay, so what's the problem? Well, I was bathing the baby, and every time they flush the toilet upstairs, it comes out in my tub. Yeah. I would say that's an uninhabitable condition, having urine and feces entering your tub when you're taking a shower or a bath, or, oh, that's disgusting, right? So what happened was, as you can see in this picture here, the sewer main that goes out to the street, before it got to the street, it collapsed. So every time they flush the toilet, it hits that blockage and backs up to the lowest point in the tub. So I told her, file a complaint with the health department. They manage the rentals in Edison. And then document, make sure you could document all your notices to the landlord, your communications. And then move out. She said she had a friend she could move in with. So I said, move in with them temporarily till I find you another place. And then notify the landlord you're terminating the lease early due to constructive eviction. And you want all your money back for your security deposit. And she did that. And then that's the way that she was able to terminate that lease early. I got a little bit more to that story, but all right, guys. So just to recap here, constructive eviction is when there's a problem with the construction in the house. This example I just gave you where this girl was renting the basement unit apartment, which was grandfathered in as a legal apartment. Every time they flushed the toilet upstairs, it hit that blockage where the sewer pipe collapsed on the guy's property. So he's responsible for that repair because it was on his property. And then it backs up into the lowest part, the tub. I would say that qualifies as an uninhabitable condition. What about you? I mean, I would be irate. I got a newborn child and I'm bathing them and that stuff starts coming out into the tub while I'm bathing them. Oh, I would be pissed. So she said she could document all of her contacts with him and him not responding to her anymore. I told her to go down to the Edison Health Department, file the complaint, because they manage rental properties in Edison. And then, the two girls down there in the health department, they looked at each other. They were like, is it? And they're like, yeah, it's him. Like they knew the guy. The owner, they're like, yeah, it's him. And the other girl was like, no. And he was like, yep, it's Chester. So like they knew him. This is a guy who owns a bunch of rental properties in Edison. And they said that he usually like does cosmetic repairs on stuff, makes it look nice, gives it a paint job. But like serious repairs and damages, he refuses to fix until they actually go down there and start fining him. So they said they were going to go out and take a look at it and all that. But in the meantime, I gave her the advice to move in with her girlfriend, notify him that she's terminating the lease early to do a constructive eviction if she wants to get out of there. And she did. So this is exactly what we did. But I told her first, I gave her the number of an attorney to call. And I said, tell him I gave you a call to ask to make sure I'm not giving you the wrong advice, because this is legal advice and I'm not an attorney. So before you do anything, make sure you talk to an attorney about it. Here's an attorney's number. He's not going to charge you for it. Just tell him I told you to call, that I told you to ask those questions. And she did. And he said I gave her the right advice. So she moved out in with her girlfriend, moved all of her stuff out, and then stopped paying rent, notified the landlord that she was terminating the lease early due to constructive eviction. And then all of a sudden now he's responsive, right? But who's he responsive to? He called me, yelling and screaming at me. Why did he yell and scream at me? He didn't even know he didn't even know I was talking to her. He didn't even know I was talking to her. Why did he yell and scream at me? Well, because he was like, well, I paid you a commission to get me a tenant that was going to be there for the full year. And she wasn't there for the full year. So I want my commission back, or you need to get me another tenant. And I was like, have you contacted her yet, or responded to her, or even fixed the problem? I was like, I know what's going on. She contacted me and told me that, how you were treating her. And I'll be damned if I'm going to be getting you new tenants that you're going to abuse like that. If that's the way you're going to be treating tenants, I'm not going to be getting good tenants for you. And then I'm going to get a bad reputation because I'm working for a slumlord, because that's how you're acting right now. I said, if you're going to be treating all your tenants like this, I don't want any listings from you. And he starts yelling about how he's going to sue me if I don't give him the commission money back and all this. And I was like, wait. First of all, I earn my commission when I produce a ready, willing, and able tenant. We get the city inspections. The lease date comes about. You got the money. She got the keys. Landlord-tenant issue, and I earn my commission, right? From this day forward, it's a landlord-tenant issue. I'm no longer involved. I earn my commission. If you can't keep your tenants because you're going to be acting like a slumlord and treating them like this, that's your problem. I'm going to sue you. Click. Hung up on him. Now, the guy kept yelling about lawsuits because he's an attorney. So he's got all the time in the world, and he figures he's going to throw his weight around and scare me. But I know, as a real estate agent, as you guys know, because I'm teaching you, when do you earn your commission? When you produce that ready, willing, and able tenant, you get the city inspections done, the lease date comes about, the landlord gets the money, the tenant gets the keys. We've earned our commission. Now it's a landlord-tenant issue, right? So you can yell about suing me all you want. It's not going to make a difference in the world. But what do we get out of this? What type of eviction is an action taken by a tenant due to uninhabitable conditions?
Constructive.
Constructive eviction. There you go. That's what I want you to get out of that whole story. So here we go. Suit for possession is the normal type of eviction that we're accustomed to. That's the action that's taken by a landlord. Suit for possession or actual eviction, because they're trying to regain possession of the premises and get the tenant out. So that's the action that's taken by the landlord. The eviction is the process of the court revoking the tenant's rights when the tenant breaches the terms of the lease. The landlord files for a summary or dispossess proceeding, and the landlord must provide a notice to quit to the tenant before filing for eviction, if they're violating the terms of the lease. The only exception that does not require a landlord to serve the tenant a notice to quit is for non-payment of rent. We need to know that for exam. There'll be an exam question on that. For any other reason, the landlord needs to provide a written notice to the tenant and serve them proper notice to stop whatever lease breaking activity they're doing. And there'll be a guide on page 345 and 346 that I call the Landlord's Guide for Giving Tenant Notice to Quit Before Filing for Eviction. I know it's wordy, but it's very descriptive. So let's first do these highlights, and then I'll show you that guide. You guys taking notes? I can't tell.
I'm good.
All right. Then if that's the case, you guys are done with this. I'll move on to the next slide.
Wait, oh no, 1 second. I just
I'll
need
move
2
back.
seconds.
It's all right. You just got to let me know. Relax. It's okay. Got our lefty here.
I got it. Thank you. I'm sorry.
No problem. No problem. You just got to let me know.
Thank
Why?
you.
That's why I ask. Everybody got it? We good? Can we go move on? You know,
Yes, thank
you
you.
gotta answer. Okay, so causes for eviction. So the landlord only needs to provide a notice to quit for any reason except for non-payment of rent. For non-payment of rent, they could immediately go and file eviction proceedings, the papers with the court. Any other reason, the landlord needs to give a notice to quit. And on page 245 and 245, 256, that doesn't make sense. 245 and 246. Okay. Little mistake I got there, little typo. $245 and $246. Here's the guide for giving landlord the tenant notice to quit. I got it all on one page here. I know in your book it's on 2 pages. The bottom of page 245 leading on to 246. At the top of that causes for, where it says causes for eviction, only highlight the one that says non-payment of rent, no notice need be given before the suit is filed. And I put a highlighted box around everything else, which you don't need to study. But this is a very useful guide for you if you're going to be dealing with landlords and tenants. I wrote it up top, Landlord's Guide for Giving Tenant Notice to Quit Before They Could File for Eviction. And if you notice all the way down here at the bottom on this slide, I also got a link for a TV show called The World's Worst Tenants. It used to be on a channel called Spike TV. It was like a guy's channel. That was a couple of years back before all the guys became so effeminate. But this was a program that was even renewed. It was a reenactment of landlord tenant agents, I guess what they call themselves. They would be the in-between contacts, so the landlord didn't have to deal with tenants. Tenants got issues, then they send out their agents there, and they go out and they talk to the tenants and see what the problems are. And they deal with disputes between tenants and stuff like that. And it was a pretty neat thing. It was a pretty neat show. The one guy, he's like an all jacked up former Marine, with his best friend and his wife, who's a former cop. And they all started this business together, this landlord tenants mitigation business or whatever. And they come across some interesting, it's a reenactment of some of the wacky situations that they come through over the years with this business that they had, dealing with landlord and tenant rental issues. They dealt with all kinds of stuff, even some real estate agents that were kind of whacked out. But this is a pretty interesting show called The World's Worst Tenants, and you could still watch it on, here's a link that I have. It is in the Class Links Word document. Here's what that show looked like. These are the characters, if you recognize them at all. They had 2 seasons. They had it lined up for another season, but I don't think that ever happened. But you can watch all the seasons here right online or on Amazon TV, Apple TV, etc., etc. Some serious issues. Home on the gun range, rub-a-dub-dub, big man in a tub. That was an interesting episode. Tenant wasn't paying their rent. So didn't pay their rent, so they sent out their agents there because the guy normally pays his rent on time. They want to see if everything was okay. Turned out that he fell in the tub while taking a shower and was stuck in there. He's a kind of a large man. Kind of got stuck in the tub and he couldn't get out. And they heard him when they knocked on the door. He's like, "Oh, but apparently he's been stuck in that tub, and they need to get an ambulance over there too to help get him out, but also to, get nutrition and liquids in the guy because, he's been stuck in that tub for a while." It's an interesting program dealing with tenant disputes. I could share that link with you if you like. World's Worst Tenants. That's what the show was called. Very entertaining. Let's get back to the slideshow. So, as you can see, non-payment of rent is the only reason that a landlord does not need to supply the tenants with a notice to quit before they file for eviction proceedings. But for other reasons like this, the tenant's disorderly conduct, 3 days notice must be given before a suit can be filed. And in this show, The World's Worst Tenants, you could see them doing this. They're serving tenants with papers for evicting them. Destruction or damage to a premises due to the tenant's gross negligence, 3 days notice required. But there's different reasons for different reasons. Do you know that a tenant can be evicted for habitual late payment of rent? Now, a lot of people are like, you can't because all they got to do is pay the rent on time and then it's back where they started from. Well, hold on a second. That's because the landlords never notify the tenant that they usually go after them for non-payment of rent, but not habitual non-payment of rent. There's 2 separate issues. So when a tenant is late on the rent, you could file for the eviction because they did not pay the rent, but you could also file a complaint for habitual lateness of rent. And then now, if they're late another time after they've been served that notice, then you could evict the tenant due to violating the terms of the lease of habitually paying the rent late. All right. So these are some interesting causes over here. And if you watch this show, you're going to see some of these actual things where the landlord is serving that notice to quit to tenants to stop that lease breaking activity that they're doing. Okay. All right, now we're going to talk about types of leases. When we talk about types of leases, we're not talking about leasehold estates. We're going to be talking about the lease paperwork. The types of leases is pertaining to the payment and what's included in the rent. So we have a gross lease. That's where the lessee pays the basic rent. That's the tenant, pays the basic rent. And the landlord is responsible for all the property charges and maintenance on the property. That's your typical lease for residential, most common in residential leases. You could find it in commercial too, but it's most common in residential. A net type lease is found in commercial and industrial properties, where the tenant pays their basic rent plus all or most of the property charges, except for mortgage financing. And the landlord's responsible for paying some of the property charges. So there's an offshoot for the net type lease. It's called a triple net, or that could be expressed as NNN. 3 N's, that's triple net lease. Triple net lease, the tenant is responsible for all property expenses. The landlord doesn't pay anything except their mortgage loan. The tenants are even responsible for paying their share of the taxes on the property. I got a triple net lease. So for my school. So I'm renting 5% of the total space of the building. I'm responsible for paying 5% of the property taxes on the property, 5% of the property owner's insurance on the building on top of my own business insurance, 5% of the landscaping fee, 5% of the high pressure water for the sprinkler system, 5% for the security system that the landlord has, and all of that. If the roof leaks, I'm responsible for fixing the roof above my unit. All right. A percentage lease, this is common in retail properties where the tenant pays a small fixed rent and a percentage of their gross sales. It could be the percentage of the gross sales above a certain dollar figure, etc. And they could put minimums in there too. And then the landlord pays some or all of the other property charges. This is common like in shopping centers, like Woodbridge Mall, Menlo Park Mall. You ever notice that there's a small store that they're doing killer business selling widgets like crazy? Widgets are the products that they're selling. It's a made-up product. I'm calling it a widget. Okay, so you guys ever see that in the mall? Where you got a store, they're busy as hell. They're selling so much of their widgets. And then next time you go to the mall, they're gone. And it's like, wow, that store was so packed. It was always so busy. Why are they gone? Well, they may have been busy selling the widgets, but the widgets were not netting them enough money to satisfy the landlord's voracious appetites. So they had to go. Okay, so a gross lease is common in residential leases, but could be used in commercial. Tenant pays a fixed rent, and the landlord pays all taxes, insurance, mortgage payments, repairs, and the like connected with the property. In a net lease, the tenant pays rent and some other property charges that may have been negotiated in the lease, whatever was agreed to in the lease. In a triple net lease, NNN is the way it's often expressed, the tenant pays their basic rent and all other property expenses and repairs and the like connected with the property and the maintenance of the common area charges, the CAM charges, except for debt services. That's the mortgage loan. And it's often used in commercial and industrial properties. You may want to write CAM there underneath that. CAM is a common area maintenance charge. And each tenant needs to pay their share of these proportionate to the percentage of the total space they're renting in the building on the property. So let's first do the highlights now in your book on gross lease. Let me know when you guys got it all highlighted.
Got it.
All right, everybody good? Okie doke. And then here's for the triple net, or for the net. Write in their triple net. Write in their CAM what a CAM charge is. And highlight this for a percentage lease. Everybody good? Anybody still writing?
Okay.
This is how you calculate the rents on commercial properties. They don't usually tell you what the monthly rent is. They'll tell you the price per square foot. So in this example, I'll just say it's triple net lease. The tenant has to pay $20 per square foot. And it's estimated that the CAM charge is $5 per square foot. Now, whatever the actual CAM charge is, that common area maintenance charge, the tenant will pay the actual CAM charges, whether they're more or less. So this is just an estimate. So you don't just add 20 plus 5, and then if they're renting 2,000 square feet, you times it by that, because you're not going to get an accurate figure of what your rent is. So instead, calculate your basic rent first. You got $20 per square foot, and you're renting 2,000 square feet. So 2,000 times 20 is 40,000. That's not per month, that's annually. So you got to divide it by 12, and your monthly rent is $3,333.33. Wow. And then if the CAM charges are estimated at $5 per square foot, let's just calculate that to see what it could be separately, and then we'll total it up. So 5 times 2,000, that's 10,000 divided by 12, it's $833.33. You add it up, now your rent is $4,166.66, including CAM charges. That CAM can make or break you, huh? It's an additional $833 a month, approximately. That's a lot for CAM. Every property's different. You got to check with the landlords, find out, get an estimate of what the CAM charges are. The estimate is not going to be what it is every month. It varies month to month, Some months you get the landscaping charge. Some months it's carried over for 2 months, and then they'll eventually plop it on you, and then you got to make it up all at once.
I had
Yeah.
a question. So we rent a building and I'm getting charged this CAM fee, but we take care of all the maintenance. So what would the CAM fee be for?
You got to ask your landlord.
Okay. Because there's no common, it's one whole building and we have the whole building.
Are they maintaining the hallways and the bathrooms, or you got them in your own units, or what?
Nope, we take care of everything.
So you got to ask them, what does the CAM charge entail? Is it a large CAM bill or a small CAM bill?
I'm going to look up the contract.
Yeah, you got to look it up. So like I got a breakdown. I just pulled up a contract from my side here for my lease. Now, I have my landlord supply me with a copy of the bills. I want proof that it's been paid and how much it is, because I don't trust their numbers that they give me. So I tell them I want a copy of the bills that you say that you pay. And then whatever that bill is, I'm responsible for 5% because I'm renting 5% of the total area of the space. So then I do that. Now, the thing that sucks with my landlord is they're sharing the first and second floor of the office space in my corner of the building with me. And I've been teaching remotely for a while now. So I shouldn't be getting any electric bill because I leave the lights off and everything is off. But yet I get a bill for the first and second floor office space, and then I should be paying 50% of whatever that is. But so they're still charging something to me here. Like the real estate tax. Let me see. For this month, my real estate tax, I had to pay $248.13. I got my monthly rent, and then I got to pay $50 for water and fire lines. And then the building insurance that the landlord has on the building, forget about my insurance, I got to pay $180.38 a month for, at least this month. Yeah, and those charges, I get different charges every month and they vary, but they give me the supporting bills so I can at least look them up and calculate it and make sure they're charging me correctly. quite frankly, I should be paying much lower in rent than I am because they just jacked up my rent 100% when I refused to sign a long-term lease with them. Yeah. So I was month to month. So they put, so I'm still month to month with them because I refused to sign a long-term lease because I'm looking for a building for myself to get the hell out of here. I'm above a commercial warehouse, you know, and I need to get a better office space for my brokerage as well as the school. And so I don't want to sign any long-term leases. So they're kind of screwing me over because of that. But I know it, you know, I'm paying way more than I should be. All right. So percentage lease, other leases, ground leases, and mineral leases we'll go over now. So percentage lease, I said that's common in shopping centers where a tenant pays a small fixed rent plus a percentage of their gross income. Now, a percentage of their gross income could be in total, or it could be only above a certain figure. And there has to be a certain minimum amount in sales. Otherwise, it won't satisfy the landlord's voracious appetite, and then they could cancel the lease because I'm not making enough money to pay them, like the widgets that I was talking about. So rent may vary according to the nature of the business and the agreement too. That's something that's pretty odd in commercial real estate. You ever notice that? Well, you may not have, but I do. I call up so many commercial landlords, even with ground leases and such. I call up to find out how much they want for the lease of the property or the structure or whatever. And the first word out of their mouth is, well, what's your business? I'm like, well, how much are you charging for rent? And they're like, it depends. What is your business? I'm like, well, that's some bullshit right there. You're going to be charging me how much you charge me in rent is dependent on what my business is? Huh. Yeah. A lot of commercial landlords do that. They do. It's pretty messed up, isn't it? Well, that's what they do. Like it or not. You don't like it? Buy your own building. You know, unfortunately, we're at their, you know, we're at their mercy there because they're the ones that got the money to have the real estate. So, you know, unless you become your own landlord, and now you see what the benefit is to being your own landlord, right? Plus, the additional benefit is everybody calls you Lord. I know, silly real estate jokes. Okay, so when they talk about other lease types, they talk about provisions added to longer terms leases, like variable leases. So if I'm signing a 5-year lease, we could have written in the lease how much the rent is this year and how much it's going to go up next year, how much it's going to go up the next year. We could either say it's going to go up by 2% or 1% or what have you, or we could go by a specific dollar amount. Or they could tie it to a cost of living index. We call that a cozy index. As published in the New York Times on the first Sunday of whatever month at the beginning of the year, whatever the cost of living index is there, that's the amount that your rent will go up by. Okay. Some landlords could do that too. You're not getting any questions on that, but you do need to understand a gross lease and a percentage lease, a triple net lease, and now we're going to go over a ground lease, which is also a triple net lease. What is a ground lease? Well, you're renting the unimproved vacant land, and then you're going to erect your own building on it. Whoa, so I'm going to build a structure on someone else's land that I'm renting? Yep. You guys ever hear of that? Called the ground lease. And you better be getting a long enough lease term on there for the juice to be worth the squeeze to be constructing a building on someone else's property, right? You better get a long enough lease that it's going to pay for itself. It is not uncommon to have 50 to 1,000-year leases for ground leases. Who lives to be 1,000 years? Well, our country's not even 300 years yet, so we're a 250-year-old country. So, yeah, these long leases, that doesn't make much sense, does it? But I guess you could have like investment funds and, business, corporations, they could have perpetual life existence. CEOs die, you get someone else in to replace them. So, yeah, you could have those long-term leases with businesses and such. Here's a famous example of a ground lease. The Empire State Building in New York City. That was erected on a building through a long-term ground lease on a building that the owner who constructed the building does not own the land. It's actually the Port Authority of New York that owns the land that they constructed the Empire State Building on in the 1920s. That was during the Great Depression to create a lot of jobs. It's amazing how quickly they built it. MetLife Building in New York, ground lease. Chrysler Building, World Trade Center Building in New York City. The World Trade Centers, remember they were knocked down by the terrorists? Well, guess what? They were constructed on land that was not owned by the building owners. They just did a long-term ground lease. Interesting. So don't confuse a ground lease with a land contract. Land contract is a type of seller financing. It's a lease to own. Whereas a ground lease is you're actually renting the ground and erecting a building on it. So are taxes going to go up on that property then once you construct a building on it? Who's going to take care of the parking lots and pave and get the snow removal and do the paving and all that? Well, that's why ground lease is also a triple net lease. The landlord says, we'll rent you our land, but you're responsible for maintaining it and paying any additional expenses. Now, what's the benefit to a landlord for having a ground lease?
Get the rent, you don't have to do nothing.
Yeah, you don't got to do nothing, and you're going to have a long-term tenant there that's going to be leasing from you. Now, even though you would make more money by constructing your own building on it and renting it out, well, you don't need to lay out all that cash to do a ground lease up front, right? Plus, if a tenant ever moves out or files bankruptcy or whatever, you still own the land that now has a building on it that you own. And you didn't pay for it. Another bonus, right? So mineral leases, also known as subsurface rights, right? The mineral leases, oil and gas leases. The landlords, they rent the land to a tenant who tries to extract the materials from the ground, and the landlord collects the rent plus a share of the profits. Like, you guys ever see those shows on TV like Alaska Gold Rush or things like that? Those people don't own the land that they're digging on trying to get the gold out of the ground. They're just leasing the land. They're doing a mineral lease, trying to dig it, get it out of the ground, and then they got to share in the profit with the landlord. But it's similar to a percentage lease because they could also put minimums that those people need to know how to get to the goal. If they don't produce enough material, then the landlord can say, well, we'll terminate the lease with you and get somebody that knows how to get the gold out of the ground. So it's similar in that regard. Okay, everybody good? Let's do the highlights now for variable leases. You just write next to it, provisions added to long-term leases. Ground lease, you're going to write, is also a triple net lease, and highlight the first sentence there. And next to oil and gas leases, just write mineral lease, because It's also referred to as a mineral lease or subsurface rights. Everybody good?
Yes.
What about our lefty? We doing good there? I can only see the top of your head. Give me a thumbs up if you're good. Lashwana? Okay. You good? All right. So, wow, look at that building. Could you imagine constructing this building on someone else's property that you don't even own? You're just renting it. Wow. It's incredible. All right. So, what are the primary functions of a property manager? Oh, let me stop that. Let me get that out of the way. What would you think are the primary functions of a property manager?
Keeping peace between neighbors, collecting rent. I don't know.
Okay, well, those are things that the landlords do, but you're too close to it. You need to back up and take that 10,000-foot view of really what it is. Don't go, you're zoomed in, you're too close because we're taking a real estate class. You're thinking landlord tenant issues, collecting rents, evicting tenants, getting tenants to fill vacancies. Yeah, they do all that stuff. But in the grand scheme of things, if you step back and take that 10,000-foot view of what it is that you're actually doing, what is your primary objective as a property manager?
Just watch for the property in general. Look out for it.
Well, it is. You got to do all those things. But in the grand scheme of things, if you step back more, the definition is really simple. It's to maintain or increase the value of the property while generating income as an agent for the owner. Right? I mean, we could sit here and debate all the little things that you need to do, all the jobs that you do as a property manager. But in the grand scheme of things, what are you doing? Your job is to maintain the property while generating income for the owner working as their agent. Right? So we do secure suitable tenants and collect rents and care for the premises, budget and control operating expenses. You decide whether you're going to hire and supervise employees versus independent contractors to do work on the property. Maybe you'll hire one as an employee and then legally bind them as an employee to the owner of the property, not to your property management company. Keep proper accounts and make periodic reports back to the owner of the property. Well, let's do this. Let's do the highlight on page 248. Property manager is someone who preserves, put a little arrow there and write, or increases the value of an investment property while generating income as an agent for the owners. Because in a nutshell, that's what you're doing. See, there's a lot of ways to look at a business. Here we're looking at property management business, right? A lot of times when we're the real estate agents, we're super hyper focused on the little details of all the mundane tasks that we do.
It's a general agent, right?
Yeah, they work as a general agent. They can legally bind their clients to a contract within the scope of their authority, which is written in their property management agreement, which acts as their power of attorney. So after you guys have this highlighted, we got that special written agreement there, that limited power of attorney, that property management agreement between our company and the owner of the property on what they want us to do for them and how we could legally bind them to a contract, if at all. Now, most real estate agents work as special agents who cannot legally bind their clients to contracts. You're hired to list the property for sale and find a ready, willing, and able buyer, or you're hired to work with a buyer to find them a property and help them get financing and all that. General agents, just like special agents, have fiduciary duties to their clients. COLD, COALD, care, obedience, accounting, loyalty, and disclosure. So on page 248, let's highlight a property manager is usually considered a general agent, whereas most real estate brokers function as special agents. And you got to go back to chapter 3 to remember all the differences there. What can a general agent do that a special agent cannot? Anybody? Anybody? Bueller? Bueller? What can a general agent do that a special agent cannot? This is from way back in chapter 3.
Take money.
Legally bind their clients to a contract. Special agents cannot legally bind their clients to contracts where general agents can. And who works as a general agent? Property managers. And what defines the scope of authority on how they can legally bind their clients to a contract? The property management agreement that acts as their limited power of attorney, that gives them that authorization to legally bind their clients to contracts. So, property managers, we need to maybe fill vacancies, right? So we find acceptable tenants. Can we be the one that actually selects the tenant? Or do we also need to run them by the property owner? It depends. What does it depend on? What does it say in a property management agreement? Do they give us that authority? So do we sign the actual lease contract as property managers with the tenant? Or do we get it and we pass it along to the landlord and the landlord signs the lease with the tenant? It depends. What does it depend on? What does it say in the property management agreement? What kind of authority did they give us? All right, so the rest of this chapter pretty much talks about, the mundane duties of property managers and such, but there's not really a lot of useful information in here. I mean, there's some interesting stuff, but it's not really useful, most of the stuff, except for setting the rental rates is an interesting one. Look at this. We're responsible for budgeting expenses, setting the rental rates, maintaining and improving the property, and maybe even evaluating the insurance that the owner has on the property. We're not insurance experts. Okay, that's all right. Get an insurance expert in to evaluate the property owner's insurance policy. Make sure they have all the types of proper coverage. Not too much of this. You don't have enough of that. You need to increase that insurance. You need to lower this insurance to have the proper types of insurance, right? All right, if you guys are interested in learning about the management field for property management, here's a course you could take called the CPM, Certified Property Manager. It was created by IREM, the Institute of Real Estate Management, in cooperation with BOMA, the Building Owner and Managers Association. And they've been around for, how long have they been around? Does the book say here? I thought it did say. They've been around for a long time. 60s or 70s, somewhere around there. And if you're interested in learning how to manage condominium associations, you could take a class from CAI, the Community Association Institute. This is a resource for those involved in managing condominium complexes, where you can have conversations with other condominium complex managers and the unique issues that they come across and how they solve them, and talk about the resources and software and all kinds of other things that can be used and approaches to manage property. So here's a bunch of links for you for these classes and for other information pertaining to property management and the property management field. Here we go. CPM has been around since 1933. Oh, they don't have it in this version of the book. That's why. I got this from a previous screenshot from a previous version of the book. This version, they removed the year that they were created. Back in 1933. Okay, interesting. Interesting. So that's under the management field on page 251. All right, and that concludes this chapter. So, before we get into the key terms to review, there's two of them. Let me also bring up, I told you there is an interesting area here on the bottom of tape 249 to the top of page 250 that talks about setting rental rates. This area is pretty interesting. I'm going to take a screenshot because I think I'm going to add it in my future slideshows so that I can read it. Setting the rental rates. All right. So in here, they talk about, I'll read this little section here. Do I have time? Not much. All right. So let's read the last paragraph on page 250 under the setting of the rental rates at the top of the page. It says if a high level of vacancies exist, an immediate effort should be made to determine why. A high level of vacancies does not necessarily indicate that the rents are too high. The trouble may be inept management or defects in the property. The manager should attempt to identify the correct the problems first, rather than immediately lowering rents. Conversely, high percentage of occupancy may appear to indicate an effective rental program if you're renting all your units like that, right? But it could also mean that the rental rates are just too low, and that's why everybody's jumping at them. So with an apartment house or an office building, anytime the occupancy level exceeds 95%, serious consideration should be given to raising the rents. So it takes longer to get tenants in there. Then you know you got it at that sweet spot. You're extracting the most possible rents from the tenants as possible. That's your job as a property manager for the landlords, right? Okay, let's do the key terms to review, page 253. There's two key terms to review. Before we get started, let's go down to key term to review 2. And next the letter B at the end of the line, write, and not paying rent, and not paying rent. Next at the end of the line B, key terms 2. You're going to write, and not paying rent. And then next the letter D, as in David, at the end of the line, you're going to write automatically renews. Automatically renews. All right, we ready? Ready to get started? Let's get this show on the road. Key terms 1. Here we go. Here we go. Here we go. Landlord's responsibility for decent conditions.
Implied warranty.
Yep, the implied warranty of habitability. 9 is A. A transfer of property by lease.
Demise.
4 is B, demise. Situation when a tenant remains after the lease period expires.
Holdover tenancy.
Yep. 8 is C. A contract between a landlord and a tenant transferring rights to use real property for a specific period of time in exchange for rent.
Lease.
That's lease. Yeah, that's a long definition for a lease, right? 10 is D. Lease for a definite period of time.
Estate for years.
Yes. 5 is E. Suit for possession. Legal removal of a tenant.
Actual eviction.
Actual eviction. 1 is F. Rental of land on which a tenant erects their own building.
Ground lease.
Ground lease. 7 is G. Another word for tenant.
Leasee.
Lessee. 11 is H. A lease under which the landlord pays taxes, insurance, and other expenses. The landlord.
Gross lease.
6 is I. Gross lease. Transfer of primary responsibility for a lease to another party.
Assignment.
Assignment. 2 is J. A tenant is forced to move because the rental unit is uninhabitable.
Constructive eviction.
3 is K. Correct. Okay, key terms 2. A lease in which a tenant pays expenses like property taxes, insurance, and so forth. The tenant makes these payments.
Net lease.
A net lease. 3 is A. Tenants remaining after the lease term without the landlord's consent, and they're not paying rent.
Tenancy at sufferance.
9 is B. Tenancy at sufferance. A lease in which a landlord shares in the gross receipts of the tenant's business.
Percentage lease.
A percentage lease. 4 is C. A lease with regular payments and no stated ending date because it automatically renews.
Periodic estate.
It's a periodic estate. 5 is D. Correct. Person who looks after another's rental real estate. What do you call that person?
Property manager.
A property manager. 6 is E. The tenancy that may be terminated when the landlord or the tenant wishes.
Tenancy at will.
Tenancy at will.
At will. At the landlord's will or at the tenant's will. Correct. 10 is F. Landlord's court action to evict a tenant.
Suit for possession.
Suit for possession. 8 is G. A transfer of only a portion of a lease. That's a weird way to write it, but okay.
Sublease.
A sublease. 7 is H. A property manager's employment agreement.
Management agreement.
A management agreement. Yeah, 2 is I. State requirement that the tenant be notified of their rights.
Truth in renting.
The truth in renting booklet. 11 is J. And landlord. Who's the landlord?
The leaseor.
The lessor, right? The lessor. They're the lessor. All right, so that concludes chapter 12. So,